I'm Tim Naftali. I'm director of the Richard Nixon Presidential Library Museum in Yorba Linda, California. It's September 27, 2011, and I have the honor and privilege to be interviewing Professor Owen Fiss for the Nixon Video Oral History Program. Professor Fiss, thank you for doing this.
Thank you.
Just so we can give viewers and future researchers some biographical information about you, could you tell us a bit, please, about your work as a clerk for both Judge Marshall and Justice Brennan?
Well, I graduated law school in 1964. I then went to work for Thurgood Marshall, who was a judge on the Second Circuit at that time, and clerked with him from, I guess, the summer or September 1964 until July 1965. And then I went on in 1965 to clerk for Justice Brennan on the Supreme Court. And as I ended my clerkship with Judge Marshall, Justice Marshall, as he's known now, he received an invitation to become Solicitor General of the United States, an invitation by President Johnson. Like many of Johnson's invitations, it was one Marshall could not refuse. But I was his last clerk on the Second Circuit. But we both went to Washington at the same time and maintained our close relationship. At that time, Court of Appeals judges had only one law clerk, and I was it, which was a great honor, but it made it extremely difficult to get any work done, since Marshall loved to tell stories for most of the day. I usually wound up working at night just to keep up with the work. But he had long been a hero of mine, and it was incredibly exciting to work for him and to get to know him. And I would say that the experience clerking for Justice Brennan was another dream come true. As you know, Brennan was essentially the architect of most of the important Supreme Court decisions during the Warren Court era. Not Brown itself, but once he got on, because he was not on the court, but once he did get on the court, he was always viewed by Chief Justice Warren as his lieutenant or most trusted member of the court. And Marshall served from 1965 until 1967 as Solicitor General of the United States, and then moved to the Supreme Court. And Marshall and Brennan became very close to one another, not just in terms of formal doctrine or how they came out on issues, but I think there was sort of a deep personal relationship between the two. And I found myself sort of very much caught up with both of them. So there were two very important figures in my life. In the spring of 1966, as I was ending my clerkship with Brennan, I began to think about what the next step was. And I had interviewed at some law schools with the eye of going into teaching, but I also interviewed with John Doerr and became his special assistant in the early fall, maybe late August, before Labor Day in 1966. And as a special assistant, I spent most of my time with John. We traveled together, we appeared in court together. I had some of my own cases, but most of it was developing my relationship with John Doerr, either when he presented a case or had to decide some issue. John left he was then Assistant Attorney General of the Civil Rights Division, and he decided to leave shortly after the Shoba trial, and actually left the division at the end of December 1967 or in January 1968.
One question, the Showboat trial, is that the Mississippi burning?
Yes.
Okay.
Yes.
Could you tell us, it's such an important case, particularly for people who study the civil rights era. Could you tell us a little bit, you worked on that case obviously with
I did not work on it much because actually, if you recall, the events, the killing was in June of 1964. So by the time that I got to the division in September 1965, the prosecution was already staffed and the people were chosen who would work on it. And I was not one. It was tremendously important for Doar's career and life and for the nation, but it was something I did not work on. Most of the things I worked on had to do with matters that came in to the office starting in September of 1965. The opening of desegregated schools, implementation of the Voting Rights Act of 1965, cases involving the cutoff of funds to recalcitrant school districts, the first employment cases that were filed during that period, employment discrimination cases. And I also had responsibility for one of John's most difficult case, and that's the case involving the desegregation of the Houston Independent School District. That became my case. That, if you recall, this is all during the Lyndon Johnson presidency, and most of our documents on the defendants were served to the school board, which of course happened to be located in the Lyndon Baines Johnson building in Houston, Texas. So it was a very, very difficult and touchy case. After John left, I pretty much decided to leave also. The new Assistant Attorney General was a person named Steve Pollack, and I admired him greatly and liked him. But I don't know, it was such an intense personal relationship with John, it seemed difficult to continue. I was not about to become a career government lawyer, and I thought my usefulness in the division was mainly being an independent soul and not caught up with the bureaucratic politics. That it would, just be, I don't know, just very important for the department and important for myself to move on. Now you must remember also, just before I go on from the period after that, that Thurgood Marshall was the Solicitor General at the very same moment that I was working in the division. And indeed, one day, John and I were going up to the Attorney General's office to make a presentation about some employment discrimination cases. And his office was near my office was near his, and in between our two offices was the Solicitor General's private office. So John thought we were running a little late, so he wanted to go up to the 5th floor on the Solicitor General's private elevator. And I said, okay, let's go. And we pushed a button. The elevator came up, the door opened, and Thurgood Marshall was standing in the elevator. And he, in his jovial but somewhat mocking tone, he said, okay, come on in, knowing that we were trespassing on his elevator. So the three of us, each one of us is quite tall, was standing in the elevator, and the elevator moved. maybe about 15 feet, and then became stuck. And this is on a Saturday morning, and the three of us looked up, and there was a sign there saying no more than 2 persons in the elevator. And we were stuck there. We missed the meeting with the Attorney General, and we had to have the fire department get us out of the elevator. So that was not the best. Anyway, but I had a very close relationship with Thurgood Marshall while he was Solicitor General, and John Doerr, and there were cases that we handled, like Walker versus City of Birmingham, which had to do with a contempt proceeding brought against Dr. King for marching against a temporary restraining order in Birmingham in April 1963, which involved the Solicitor General's office. So there was a pretty close working relationships. In 1968, after John left, I decided to begin my academic career, and I took up a position at the University of Chicago. And I stayed at Chicago for 6 years until, I would say, the summer of 1974.
Let me ask you before we go on, I just wanted to ask whether what cases, interesting cases you worked on with Justice Brennan in the year you clerked for him.
At that time, the justices had only 2 law clerks. Now they have 4. So once again, it was a pretty intimate relationship, and it also meant that all manner of cases, almost every case came before me as well as my co-clerk. Remember, the clerkship is taking place in 1965, the fall of 1965 over to the spring of 1966. One line of cases had to do with the Voting Rights Act of 1965, which was passed in the spring of 1965 following the Selma March. And so one group of cases that I worked on with Justice Brennan were the cases arising under the Voting Rights Act of 1965, cases like South Carolina versus Katzenbach, to engage examining the constitutionality of the statute. Probably the most significant case of that term under the Voting Rights Act was a case, and it's called Katzenbach versus Morgan, a case involving the power of Congress to enact measures to further, though not restrict, the power of Congress to implement the 14th Amendment and implicitly implement the 15th and 13th Amendment as well. And Katzenbach versus Morgan was an important affirmation of congressional power to act as a coordinate branch of government to enhance the egalitarianism of the Warren Court. In recent years, that's become under attack by the Rehnquist Court, and I presume it'll be continued by the Roberts Court, but that was a basic building block of that era, and indeed turned out to be the foundations of the Civil Rights Act of 1968, and then subsequently the Voting Rights Act of 1982, and then the Civil Rights Act of 1991. Another group of cases that were important were the school desegregation cases. Although this was 1965, most of the previous decade was testing the validity of Brown on its face. The metaphor that we used, it was sort of like cracking the ice to get, there were about when I joined the division, in 1965, there were about 2,000 school districts in the South that operated in open defiance of Brown versus Board of Education. But as we got closer to that date on the Supreme Court, we began to deal with the understanding of what desegregation is, or what Brown would require. Not just the paper compliance, but the performance of the school district. And I worked, for a reason I'll explain in a moment, I worked with Justice Brennan on a lot of those cases. I think they were given to me as opposed to my co-clerk, maybe because I had clerked for Thurgood Marshall before, but also in my third year of law school, I wrote a paper. Everyone was required to write a big paper, and I wrote a paper, too big, but a paper on northern school desegregation. What would be the implications for the North once Brown got out of dealing with the dual school system of the South. And in January of 1965, while I was clerking for Marshall, that paper was published in the Harvard Law Review. And so by the time I clerked for Brennan, I was just a little kid, but I guess I was seen as someone who had a lot of expertise on school desegregation matters.
Did you, because later this would be significant, did you look at the difference between de facto and de jure segregation and how to deal with the...
Yes. At that time, the distinction between de facto and de jure was not as clear as it is now. At that time, there were very few cases, no Supreme Court cases, but they were beginning to sort of conceptualize it in terms of this distinction. And my view was to sort of whittle away at the distinction on the theory that the government is responsible for the foreseeable consequences of its action. And in fact, there are differences between so-called de facto and de jure, but not a difference that's captured by the word de jure de facto. I think both cases, the government is responsible for the segregated pattern. But that's what that was essentially the subject. Now, when I clerked for Brennan, the cases that we dealt with were Southern cases from the 8th Circuit and 4th Circuit, not so much the 5th Circuit, but the Supreme Court began to articulate what it meant to desegregate a school. And those early cases were the stepping stone for a very famous case in 1969, or 68 maybe, 68, while I was still at the division, called Green versus New Kent County, where the Supreme Court began to give some substantive content to the duty to desegregate. Also, and this may account for why I didn't deal with this case in the Department of Justice, the Neshoba case, this was also the term in which the Supreme Court decided important cases on state action, a case called United States versus Guest and United States versus Price. And the question is, to what extent do state officials have to be involved in a crime before the federal government can take jurisdiction over the matter? And Guest went far in explaining what that involvement could be. And United States versus Price, which involved the Neshoba prosecution, also entailed that question, because although there were deputy sheriffs involved in the group that were charged with killing these civil rights workers, there were also lots of private non-state officials, and the Supreme Court held that involvement of the deputy sheriff was sufficient, but the private individuals, as part of that conspiracy, could also be prosecuted.
You go into academia, you make the choice. You're at the University of Chicago. When do you go to Yale?
Well, it's an interesting story. I'm at the University of Chicago starting in 1968. In in this fall of 73, I taught at Stanford Law School in California. And then returned to Chicago to teach the balance of that year. I left Chicago in that end of that year, and as my mother put it, anyone has to be crazy to go from Palo Alto to Chicago in January. And during that whole spring, I was toying with the idea of either going to Stanford, staying there permanently, remaining at Chicago, which I liked enormously, or going on to Yale. And sometime in that spring, I decided to go to Yale and joined the Yale Law School faculty in July 1974. Now, the interesting thing is that in January, very early in January, as I was still in Palo Alto, I received a telephone call from John Doerr. John Doerr had just become the chief counsel for the impeachment inquiry of the House of Representatives. And John and I speak about a lot of things and did before, but this was a telephone call about the impeachment inquiry, in which he asked for my advice about developing the staff, but also invited me to help him out. So from January 1974 to middle of August of 1974, I was teaching in Chicago up until January, trying to make my life's decision of where I'd wind up. And at the same time flying back and forth from Chicago to Washington to consult with John on the impeachment inquiry. Then in the summer, and academic summer begins like June 1st, as I was packing up my house and my 3 children and my wife and looking for a house in New Haven, and as I was moving, we didn't have a house. Eventually we found a house, but it wasn't ready, and we had to stay in a friend's house. But during that summer, and as I was moving from Chicago to New Haven, I was also commuting down to Washington to continue in my capacity as a consultant for John. So it was a very hectic, extraordinary time, just the move, but then to have the consultation, it was an extraordinarily grueling time. As you probably know, John works very hard, works 7 days a week. It's expected, at least of me, that I'll be working at least as hard as he is. And I would go down and sometimes stay awake without sleep for 2 or 3 days before I returned to New Haven or Chicago, and I would just come in and out on that basis.
When he called you, what did he want you to do?
Well, I think he wanted to get my advice about young staff members and people that he was building the staff at that very moment. And I mentioned some people. He had very high standards of he knew a lot of people I knew and was not anxious to take a lot of them. He was meticulous in hiring people who had not publicly taken positions one way or the other on the issue. One of my friends at that time, and a person I admired greatly, and John was very inclined to hire on the basis of his talent and capacities, but it turned out that he had signed some petition that addressed the issue of whether the president should be impeached. knowing John from the division, I mean, he conceived of this task very similar terms as he conceived the running of the division. As you know, John is a Republican. He served under Ramsey Clark and Nicholas Katzenbach, and worked during the Kennedy years and also during the Republican years. But John was not political. I mean, he believed in the law, and he believed in the neutrality and objectivity of the law, and he ran the division to convey that impression of fairness and impartiality. When he spoke, the courts listened. When he spoke, the courts listened in a way that they would not listen to the lead counsel for the NAACP or a private counsel. He felt, outside the Department of Justice, there's a written, the United States wins when justice is done. And I think that was John's abiding goal, always to figure out what was just, apart from politics. And he was very determined to build a staff that would be impartial and capable of gaining the confidence, not just of the Democrats, but also the Republicans on the House Judiciary Committee.
Did he convey to you, when he spoke to you, a bit of surprise that Chairman Rodino had asked him to take this job?
No. I mean, he's a modest person, but no. Indeed, it was a perfect choice. Brilliant choice.
So had he thought about, did he need some help in looking at the precedents, the previous examples of, the one previous example of presidential impeachment and the other impeachment cases involving judges and one justice? Did he ask you to look at those and see whether there were any useful precedents for them to consider?
Well, that really wasn't my role. I mean, John had a very large staff, and he had a number of people looking up the presidents, looking up the history. But he had to sign off on everything. I mean, it wasn't enough that he had a 28-year-old lawyer doing a memo on the grounds of impeachment. He had plenty of people doing those memos. He had to sign off on the ultimate, the first big project was something on the grounds of impeachment. The Constitution says the president can be impeached for high crimes and misdemeanors. And the question that he had to confront was, what does high crimes and misdemeanors consist of? Specifically, does it require that the president violate some criminal statute, or was there some improprieties, though not criminal, or appropriate grounds for impeachment? And he had plenty of staff researching that question, and they all submitted the drafts and memos to him. But John worked, he didn't take any person's word for it. I mean, he never relied on anyone. He had to make the judgment himself. So my task with the grounds of impeachment was to get all these memos together and to put them into a document that John would be prepared to sign. So I worked almost like a law clerk to John Doerr, of saying, these are the positions that are outlined, makes sense, this doesn't make sense. I mean, the people he had working for him were wonderfully talented, and some went on to write books like John Labrovitz, who you'll probably interview. But my job was to come in when all their work was done, and for 5 days, 3 days, a week, analyze the whole thing and tell John this is what he should do, this is what he should sign off. So I was like the the last, I think everything went to John. No one reported to me, but I was like the last step before John. And that was replicated also in an area that didn't, one of the grounds of impeachment is sort of almost a legal question, but when it came time to write the factual presentation, the information, I got the reports from everyone, and I basically was John's law clerk again, saying this is what we're going to say on the basis of all this information.